Hello, everyone. So we are live. Can somebody tell us if they can hear us? Okay, perfect. Yeah. So welcome, everyone. Uh, this is uh, this is the second part of the web series that we're doing on introduction to the international commercial arbitration. And at the outset, I would like to take a few names and thank them. First and foremost, the IIT Delhi Alumni Association, our recent president, Mr. Rohit, and the previous president also, Mr. Bal. And I'm really glad and very thankful to Ms. Neeti Sachdeva, who is the registrar of MCIA, and she also is an expert. And she is there with us in case we have any queries, and she'll be more than willing to answer our queries. So, friends, in the first webinar that we had done, so we had taken a session on the introduction to the international commercial arbitration, where we dwell upon what the international arbitration is all about. And then we talked about the party autonomies. We briefly touched upon what an arbitration agreement is, and then went on to even discuss about what are the constituents of an award, and the New York Convention, the model law, the UNCITRAL model law, and the various institutions which are administering arbitrations as of today.
Challenge
Yeah,
to arbitration,
yeah,
enforcement of award,
challenge enforcement.
jurisdiction. We did try to cover a lot.
Yeah, that's right. So as we begin this second webinar today, so this is we'll be focusing more on the arbitration agreement, the drafting of an arbitration agreement. What are the essential ingredients of an arbitration agreement? So what we must understand is why are we giving so much importance to an arbitration agreement? Is whenever you get into a commercial contract, whenever the parties get into a commercial contract, as important is the contract itself is the arbitration agreement, because if the parties are willing to resolve their dispute and don't want to get into litigation for various reasons, and if they have any intention to get into an arbitration, the arbitration agreement must be valid. And how is an arbitration agreement valid? There are few criteria that one must keep in mind. So we will be touching upon that. We will also be touching upon what are the key ingredients of drafting an international arbitration. Although there are various institutions which suggest a draft arbitration clause, but you know what happens is when the parties are getting into a contract, I think a dispute is the last thing on their mind. So when they're drafting a contract, they would ask one of their counsels to just put in a line or two that yes, in case there is a dispute, we will insert an arbitration clause so that tomorrow we can get into an arbitration, because we don't want to go to the courts, because courts, the cases keep pending for a long time, especially in the Indian jurisdictions. So now, but it is very important that we do take good care of how we draft our arbitration agreement. So the party autonomy is indispensable as far as the arbitration agreement is concerned, because courts recognize there's something called as l'autonomo mide la volante, which means the autonomy of the will. As far as you are abiding by the law, the autonomy of the parties, the will of the parties is supreme. The two parties have agreed to resolve a dispute in a particular manner, and you take care of the basic fundamental substantive law of that country, of that jurisdiction. You are in your own rights to conduct that arbitration in the way you want it, the parties want it. And as we are now also a faculty for arbitration, we go to institutes and we conduct classes, and then even also the corporates. So there is a lot of contracts that come to us. Now, what happens is once the arbitration agreement has been inserted in a contract and that contract has been signed, then the parties, after a dispute has risen, the parties come to us and say that how can we change this agreement? But no matter what you do, one must remember in mind that it is very, very difficult that the two parties will agree on anything once a dispute has arisen. So it is very important that you properly take care of your arbitration agreement and you insert all the
I would say even to the extent that once a dispute is arisen, if you wanted to appoint XYZ, but if the suggestion comes from me, you will definitely make sure that he or she doesn't get appointed. So I agree with you on that. Yes.
I mean, there's a lot of things which you need to take care of. Yes. So now, then we talk about these model clauses and all, like Hunter says in his book. By the way, Martin Hunter, the book on international commercial arbitration is one of the finest books that I have come across. And I find it pretty voluminous and elaborate extensively. You can understand the various concepts. So if you can get your hands onto a book like that, it's very good. Like I would like to quote from his book. What Hunter says is that, unlike Venus, these conventions did not, rise out of a sea fully formed. So these conventions have taken a lot of time. In fact, just to mention that conventions, there was a Geneva Convention of 1923, in fact, which actually dealt with the recognition and enforcement of international arbitration agreement. And then the Geneva Convention, that was a protocol, and the Convention of 27. And the finest important thing which was done in 1958 is by coming off of New York Convention of 1958, which is a convention on the recognition and enforcement of foreign awards, which also deals. It's actually a myth. The people think that the New York Convention of 58 is only to deal with the recognition and enforcement of foreign awards, but it certainly deals with the arbitration agreement, and it provides the validity and enforceability of an arbitration agreement as well as an award. So now let's get to the arbitration agreement. So what are the requirements of an arbitration agreement? That the arbitration agreement has to be in writing. It deals with either the existing dispute or a dispute which has already occurred, and that it must be kept in mind that when we're talking of arbitration agreement, it is a dispute that has arisen out of a legal relationship between the parties. But it's important to understand what a legal relationship means. And then the subject matter that the dispute is talking about is capable of being settled through arbitration. That means the substantive laws of that country, when we read in detail, must say that this contract we got into is valid. It's not a contract which is against the state principles. So now let's talk about the first requirement of the arbitration agreement being in writing. The model law talks about. What does it say now? It gives basically two options. Initially, it was very much required that the arbitration agreement is in writing, has been consented by both the parties and signed. But as of today, it stands that the arbitration agreement has to be in writing, but in any form. So basically, what I'm trying to say is the principle that we must remember here, or a test, is that it is evidenced by text. So let's, for example, say that two parties went into a contract and later at some stage they said, yes, in case of dispute arises, we would settle the dispute through arbitration, right? And then those minutes of the meeting were either minuted or they're transcribed, and after the transcription has been basically accepted by the parties, so there is an existence of an arbitration agreement there, which can be produced in front of the tribunal. Also, let's say the arbitration has begun, and the statements of claim and the statements of defense has been submitted by both the parties. And in the statement of claim, the claimant has alleged that there is an arbitration agreement which has been invoked by his, in this statement claim as well. And the defendant or the respondents have given out their statement of defense where they have not denied this claim of the claimant. There is an implied consent to agreeing that there is an arbitration agreement with the contract, and thereafter the tribunal will take a cognizance of that matter. There is an implied consent. The both parties have agreed to an arbitration agreement, and the arbitration will have its jurisdiction, and the matter will have to be solved with arbitration. So basically, again, the principle that we must follow is the substance over form. So now, as long as there is some written evidence to an agreement, and to arbitrate, the form in which that exists is actually immaterial. So the higher moral is that we need to have there's a substance, that there has to be an intention of both the parties to get into arbitration, as far as the tribunal can establish that yes, both the parties wanted to go into arbitration for this dispute, I think there exists a jurisdiction for the tribunal to rule over that dispute. Now, option two, there is an option two also in the recent amendments of 2006 that does away also with the requirements of its form. Basically, I would say what is that is about certain jurisdictions do agree that they don't actually need the arbitration agreement to be in written as well. There are very few jurisdictions like that, but yes, there exists a provision like that. In those jurisdictions, in case the parties have also agreed verbally also, and there they can be it can be established in front of the tribunal, then there exists a jurisdiction. There are few cautions that we must take here also. That as far as the capacity of the parties to go get into a contract, so basically the contract itself is basically an entity in itself, and that the arbitration agreement is also like an individual contract. So there is a principle of severability. That means that if the contract is rendered invalid for any of the reasons, the arbitration agreement shall still exist and shall still remain valid as far as if it is a valid arbitration agreement. But now what happens is once the award has been given under jurisdiction and the award comes for an enforcement, and the tribunal takes a view of that whole thing, or the courts even take a view that they will always try to revalidate that arbitration agreement. Whenever an award comes for an enforcement under jurisdiction, that court will always try to revalidate that arbitration agreement. And when they look at the validity of that arbitration agreement, they would look at those fundamental principles and the substantive law. So for example, if a arbitration agreement, the contract was valid in a jurisdiction because of, let's say, age restriction, and in certain jurisdiction it might happen that he was below, let's say, 18 years or 16 years of age. A person of 16 years can sign a contract in Russia, but in India, a person of 16 cannot sign a contract. So it is incapacity of the party to get into a contract. Similarly, incapacity for the party to go into the arbitration agreement. So various jurisdictions will take a different view of the arbitration agreement and its validity as well. So we must take care of that. So remember, where you want to enforce your award must be kept in mind when you're drafting your arbitration agreement. And similarly, therefore, the enforcement, whenever like there is an arbitration award which is coming for an enforcement, what is that law? Substantive law of that country must always be referred to before we even give out the agreement. Yeah. So then something called as the subject matter for a settlement by arbitration. So what we must understand is, although the arbitration is a private affair, but it has public consequences. So no matter what you're doing, but that is why that governing law, when we're talking about the governing law, we will touch upon. So what we will do is, so once I have briefed you about these ingredients and a little bit touched upon the various aspects of an arbitration agreement and why is it important, I would request Registrar MCIA, Ms. Niti Sachdeva, to basically elaborate upon the ingredients. Basically, also, I would tell you that we had also started a community forum for discussions on arbitration, which we could address during our webinar, and we have received around 78 queries. So although many of those queries are similar and they're common, so we would like to touch upon basically 4 or 5 of them which are of important nature. We would like to touch upon that and give you answers for that. But I request Niti also to touch upon those things like what a seat versus the place of arbitration. That's one of the important things that I think that most of the people confuse with, because even in the literature you'll find that the venue and the seat and the place, they have been used interchangeably without not much understanding of what it is. So next thing is the general rule for the subject matter to be able to be settled by arbitration. You must understand is that any natural or legal person who has the capacity to enter into a contract is also capable of entering into an arbitration agreement. So every time I talk about contracts, I talk about arbitration agreement because I am using them as 2 separate contracts. And that is what I would like all of you to understand, that there are 2 different entities themselves, because they still stand valid in absence of each other. Okay. So, what does in case let's say the parties have gone into arbitration and one of the parties gets to know that there is an incapacity of the other party to get into arbitration agreement? What are you supposed to do? So, I think at the earliest available opportunity, you must bring this aspect to the tribunal and say that the arbitration agreement is inoperative and it is incapable of being performed. Or even once the award has also been given, then also the parties can contest and bring this challenge. The arbitration agreement is invalid due to the incapacity of the other party to get into the contract itself. Now, what are the various key ingredients of an arbitration agreement? I would just touch upon very briefly. There is a plethora of commentaries which are available to how to draft an arbitration agreement, and various international arbitration institutes also give out a kind of a model arbitration agreement clause, which is kind of a suggestion. They suggest you, but they are very common. I mean, anybody could use them because they have the basic minimum essential requirements of an arbitration agreement, in the sense that any dispute arising out of or in connection with that particular contract would be referred to arbitration. And what other things you could substantiate the agreement with, or it can have a, other supporting elements are like, what is the seat of arbitration you would like to have, which is important because ultimately the procedural law is of that country would be applicable to the arbitration. What I'm trying to say is, for example, you have chosen your seat as India, so the Arbitration and Conciliation Act of India would be applicable. And something called as, there's another thing which is a substantive law and also called as the governing law. So another choice you must also make early in your contract and in your arbitration agreement itself is, what governing law would you like to have? Now, the governing law is the law, like for example, the contract law of India. You're getting into a contract, your validity of a contract itself would be decided. The capacity of the parties to get into a contract would also be is an extension of that contract itself. So the governing law of a particular jurisdiction is important to decide the capacity of the parties to get into a contract. The validity of the arbitration agreement will also have to stand the test of that particular governing law. And the validity of the contract, the subject matter in dispute. So all these things would particularly be assessed in the light of the governing law of that particular jurisdiction. Language is another thing. Language is also important because sometimes I've seen that two parties have gone into an arbitration, and at the later stage when the tribunal was formed and witnesses were called, and then they realized that the tribunal does not understand the language of the witnesses, or one party does not understand the language of the other parties, or even sometimes when the third parties are involved. So always mention that what is the language of the agreement, the arbitration is going to be. And in the absence of Niti, probably you can elaborate on that. Sometimes it happens that parties have forgotten to insert what language of arbitration is going to be. In that case, what do you think the tribunal would do?
So, Madhvendra, I'll tell you, there is a good that you brought this question. Yeah. Actually, if you're in Korea, so if you've chosen your seat to be Korea, but you have not chosen a language, you'll be bound by the Korean language itself. So you will not even be aware of it, but just by choosing a seat, you have subjected yourself to a language. So I agree that choosing a language is important. What generally will happen is that if parties have not chosen a language, then when the first procedural hearing happens with the parties and the arbitral tribunal, the tribunal will try to get both the parties to agree on a language. Generally, English is the language, but as you know, sometimes if you have probably a French party and an English party involved, it can get a little difficult to get them to agree whether French should be the language or whether the English should be the language. So many a times you think, why should language be an issue? But it can actually become an issue as well.
That's right. So what would you like to first start with a model clause? Now, since you come from MCIA, could you take us to what a MCIA model clause is, and what are the various, how could somebody insert an MCIA model clause in their arbitration agreement? And then what are the other features which can make it more solid and more effective? Arbitration agreement not only has to be valid, not only has to be, uh, proper in totality, but it has to be efficient. So for an arbitration agreement to be efficient, trust me, it takes a lot of time. Your counsels really have to burn the midnight oil to actually understand a lot of aspects, because you must understand at the very beginning that what kind of disputes may arise out of a contract. There is a range of kind of disputes, and every kind of dispute may require your choice of seat, the governing law to change. And then also, various factors. I'm sure Niti would cover on those aspects. What is the model clause that you would propose, and what do you think are the essential ingredients for the arbitration agreement to be effective and not only valid?
Right. I think I should take a step back and do a formal first thank you. Thanks to you, Madhvendra, for definitely putting this all together. And thanks to IIT Delhi alumni for recognizing that international commercial arbitration is an important subject and that it does require a little bit of more, I would say, deliberations. Thanks to the past president, Mr. Bal, who could, effectively put this there. And now Mr. Rohit, who has carried forward this mantra. And under his leadership, we are continuing with the webinar. So we're very glad to be associated with an organization like that. And special thanks to Mr. Madhvendra, who's an MCIR as well, and did understand and I would say apply that how important these small concepts can really become. Let me just try to make it a little more lighter. Like Madhvendra said that people don't negotiate dispute clauses. Why don't they negotiate dispute clauses? Because when you're entering into a contract, it's a happy ending, right? Your happy ending, you're getting into a financial commitment. Everybody's trying to look at making money. Why would you want to look at something which will probably drain you out of your money, which will take you to another level of having difficulties? So very, commonly, if you pick up any of the commentaries, arbitration clauses have been worded as the champagne clause or the midnight clause. The reason is, and this is something which I have been privy to as well myself, just like Madhvendra has done in this room, made it a chilling room for me not to be able to concentrate on this, but to be thinking of the climate and the weather and how cold it is. Just on a lighter note, you have negotiations going on, and these are hardcore negotiations. The two sides law firms sitting across the table, trying to get their clauses in. How will they exit? What will happen? What are the financial commitments? What are the delivery terms? All of it. And finally, it's time to sign on the dotted line and to pop a champagne. So one of the people in the corporate team will rise up and say, oh, sorry, we didn't talk about the disputes clause. So they will send one of their juniors and say, can you get us the last contract, pick the clause up and just paste it here. It's happened across the world. It's not something common to India. And that's why it's called as the champagne clause. But why is it important? The importance is this, that when dispute arise, and they do arise, we all know, at that time, it is just too late to go back and negotiate your contract. I always say that arbitration agreement is like a door. If your door is not oiled well enough, if it is ajar, you can't open it. Though I'm sure litigation lawyers don't complain of it because they get to litigate purely on the arbitration clause itself before even they go into the dispute. But in an ideal situation, at least your dispute resolution clause should be clear so that you can get your disputes resolved. That's the whole idea. Some of the times what happens is that before I go, I'll digress a bit. I'm sorry, Madhvendra. Before I go and tell you what an ideal clause should be, what are these different factors? What sometimes happen, and maybe you have an arbitration clause which if you look at it, says it has to be an arbitration, but some of the factors are not very clear. So there's a term coined for that as well, which is called as the pathological clauses. So basically, the intent could be there, but it is not clear. The intent is not clear. So you do not know what to do about it. And in our presentation today, we'll try and cover some of these very interesting pathological clauses as to why people drafted it. We do not know how they came by, and thanks to the lawyers that they exist in the different jurisdictions, and they've been interpreted by the courts. Some saying that they can uphold them, some saying we can't uphold them. What I'll start now with is that Martin, do you want to narrate the arbitration clause and take it
out? Yeah, okay. Why not? So I'm giving you an example of a draft model clause for arbitration agreement. So it says that any dispute arising out of or in connection with this contract, including any question regarding its existence, validity or termination, shall be referred to and finally resolved by arbitration in accordance with the arbitration rules of MCIA, the so-called MCIA rules, and which rules are deemed to be incorporated by reference in this clause. Or I would here also like to mention about sometimes a particular contract when drafting an arbitration agreement which only have a reference to some other principal contract or a main contract referring to arbitration agreements. In such a case, it is important that not only the reference is drawn, but the reference is drawn in a manner that it proposes that yes, the parties are willing to get into an arbitration in case a dispute arises in this contract. Tomorrow, if you want to insert an arbitration agreement in a reference to some other contract, because parties do a lot of contracts like one after another, like multiple contracts. So sometimes they don't really have to get into a arbitration agreement every time, establish protocol for their arbitration. So you can refer to a main contract or the particular contract you have done earlier, but always remember that the reference you draw is in a way that you give out your consent to get into an arbitration if the dispute arises in this particular contract as well.
And also, if I may quickly add to there, especially in the cases where you have, these huge construction contracts. Now you have a main contract, which let's say has a clause which says that if a dispute arises, shall be resolved under the institution rules of MCIA. Now
Yes.
the contractor then subcontracts a part of the work to be done. And then there is a contract between this contractor A and a subcontractor B. And that clause says that if a dispute arises, we shall go to the court. The subcontractor C then subcontracts to a subcontractor D. And this is very common, especially in large construction infrastructure projects, that there are subcontracts happening. And now this contract between C and D provides that if a dispute arises, of course, for the same work, then it shall be referred to ICC, let's say for arbitration. So Madhvendra is very right that if you have a main contract and you're entering into multiple contracts subsequently to it, it might be best to have the main referenced arbitration clause then to be, carried forward in your subsequent contracts as well.
That's right. So next thing, one of the important factors is the seat of arbitration. So let's now get on to the seat of an arbitration. So what is the seat of an arbitration? There's a word called the lex arbitrae. The seat does not mean anything more than or less than that the lex arbitrae is basically the procedural law of that jurisdiction.
Absolutely.
So that means arbitration is basically a procedure. There is a procedural law which will decide how the arbitration is to be conducted. So Niti, tell me one thing. Like when I go and talk to people, and even in the corporate, a lot of people ask me that, how would you like to put it that I want to go into an ad hoc arbitration? By the way, we had touched upon ad hoc versus institutional arbitration in our first webinar. So you understand ad hoc arbitration means the two parties are going into arbitration, the appointment and everything. You basically consult an ancestral model law or a model law as per your whatever is in the arbitration agreement only, and then you get into a arbitration. You form a tribunal depending on what you have chosen to be appointment of an arbitrator, and then you can refer the basic model law, which is either an ancestral model law, right? But in an institutional arbitration, you would have referred your matter to an institute, for example, MCIA, the only international arbitration institute in India as of today. So once you have said that you were going in for the MCIA rules for your arbitration, then what happens is your arbitration is completely governed by the rules of the MCIA. Yes. So you should be aware of what the rules are. And then the appointment of arbitrators, how is the statement of claim and the statement of defense is going to be processed, how much time is going to be there. And basically all the kind of administrative issues will then be handled by the institute, and they will have their own processing fee for all of them. Correct.
So, Madhvendra, with your permission, before we go on to seat, let's just look at the clause which Madhvendra read out for you. He said, any dispute arising out of or in connection with this contract.
The language of it, right?
Why is this important?
This is important, yes.
Because when you're drafting dispute resolution clause, it is very, very essential that you have a certainty of a dispute. So I'll give you an example. There was a decision, I think, of the Luxembourg court where they had this arbitration clause which said, all possible disputes in connection with this contract shall be resolved by arbitration. And so what do you mean all possible disputes? There is no certainty of disputes. So that's why it is very important that these some basic concepts saying that any dispute, not possible dispute, any dispute arising shall be resolved. The second part of it, what he said was under the MCI rules. So when you start to draft your arbitration clause, or I would say your dispute resolution clause itself, there's a first leg to it, which is you need to decide whether you will go to litigation or whether you will go for arbitration. Of course, today the whole webinar series is on arbitration agreements. So we're not touching about the litigation aspect of it. We'll presume that the parties have agreed to arbitrate. The second most essential question then comes is that whether you will be going under ad hoc system or under the institutional system. Like Madhvendra just very secondly provided you that what is an ad hoc arbitration, what's institution, and how it really plays out. So once you have decided as to what institution you want to go for, then you look at their rules. You see what they provide, the fees, what are the timelines that they have, what are the different kinds of rules they provide. So, like just to give you an example, there are certain institutions like MCIA, SIAC, ICC, which provide for the scrutiny of awards. So, once a tribunal has given an award, what will happen? They will send the award to the secretariat of the institution. Institution will not go into the merits of the award, but will only see that all the issues have been dealt with. I'll give you a very very interesting example. What happened? We had an award. This is not in my role as an MCIA, but one of my previous organization. We were to scrutinize an award. We got an award which said XYZ party is awarded an interest of 10% per annum. And when we were vetting the award, or I would say we were scrutinizing the award, the question that came to our mind is that, is this an interest which is a simple interest, or whether it is an interest which is a compound interest? Can you imagine the implications of it? If you have an award like that, which is then published, or one of the parties has it, I can guarantee you they'll be fighting out in the court only to interpret the award on whether the interest granted was for simple or compound. And for an award which runs into crores, that can be a huge amount. So that's how scrutiny helps. You're not, so we wrote to the arbitrator to say that, would you want to clarify what are you intending to grant the parties, a simple or a compound interest? This is just one of the examples. Institutions like LCIA, AAA as well, to best of my knowledge, do not have a concept of scrutiny. So if you would prefer that your award should get scrutinized, then you might want to pick up an institution like that. Secondly, MCI rules provide for something called as expedited procedure. So now, if your dispute is about up to 10 crores of this, is amount in dispute is, then you might want to go for something like an expedited procedure. So it's not a long drawn process, but you get your award in 6 months' time. ICC has something called as a fast track arbitration, something very similar to what expedited procedure is, but a little more nuanced, I would say. Some institution rules provide for joinder of parties. So like, let's say we have, like I said, we had an arbitration clause between A and B, the main contractor and the contractor B, but C was not a party to that arbitration agreement. Now, once a dispute arises and I want to make C a party to it, can I do it? Probably not, because party autonomy is not there. C never subjected itself to this arbitration. In a court, maybe you can. So some of the rules provided how you can join third parties to your existing arbitration. Some rules are silent about it. Then there's a concept of consolidation. So let's say, again, party A and B, under the same contract, have started an arbitration, appointed an arbitral tribunal. And then they have another arbitration, which they're starting under the same arbitration for some other relief and making another party a part to it. Now, the two arbitrations should get consolidated. So there is a consistency of the award. Now, some rules may provide for it and some rules may not provide for it. So that is why, and of course, cost play a major role, because ultimately, I would say, especially for an Indian market, we're a very price sensitive market. So if you have, when you're deciding your institution, you might also want to keep in mind what are the costs involved. What is the arbitrator's fee? What is the fees of the institution? Again, institutions like LCIA, AAA, they charge their arbitrators and their administrative fee on a per hour basis. Whereas institutions like ICC, SIAC, MCIA are based on an ad valorem system.
Niti, that brings me to a very uncomfortable question.
No, that's fine.
Why? So, MCIA, yes, is doing pretty well in our country, but why do you still feel that there is a trend of Indian parties to choose Singapore or London or Paris as their seat?
Yes. So
Yeah.
I totally agree. I think that brings us to the next question of seat, really. And
Yeah. So
given
tell
we're
me,
looking at time, we
yeah.
probably
So
should. Yes.
recently, I've been reading this judgments also. So, what is the present status as to the two Indian parties, wanting to have their seat abroad? So,
Right.
what do you think? Would you dispel the myths that people wish to have?
I wish the Supreme could do that, but they didn't. So people have followed, and for the sake of the other people as well, this was a major issue which arose because very commonly we would see that two Indian parties would have a seat in, let's say, Singapore or London. Now the problem is that can you do it? So Atlas Corporation was one judgment, I think Kerala High Court said, where they said that you could have a seat outside of India. And when the matter went up to Supreme Court, they didn't really decide on this particular issue, but they did say that on the facts of it, because there's a foreign element involved, so you could have a foreign seat. In really, they interpreted saying that it was not typically two Indian parties, but one party could be said to be foreign. But in 2018, the Delhi High Court also has said in one of its judgment that two Indian parties can have a seat outside of India. So you can have a seat outside of India, but you can't have a governing law of any other country. And that brings me, with your permission, if I could just discuss the concept of laws in arbitration. It's a very tedious subject, and as Madhvendra said, that anybody who's interested in the study of arbitration, I would say that the International Commercial Arbitration book by Alan Redfern and Martin Hunter is definitely a starting point. You have some very good treatises by Leo Mistelis and by Gary Bourne as well, but your starting point could very well be Hunter. And he says that within one arbitration, you could at least have 3 to 4 different laws applicable. Very complicated. Let's take an example one by one. Like Madhvendra said, seat. What is really seat? If you are two Indian parties and if you're choosing a seat in India, I would highly recommend do not say that seat is India. Say your seat is Mumbai, India, or your seat is Jaipur, India, or your seat is Delhi, India. Because that basically means that tomorrow, if I have to get my award set aside, where do I go? I go to the seat court. So the supervisory jurisdiction of the court will be of the seat court. That is why it is important. Now, let's go to governing law. What is governing law? Madhvendra spoke about substantive law. He said Contract Act, Companies Act. There's a shareholders dispute. How do you decide a shareholders dispute? That will be according to the Companies Act, oppression, mismanagement. So governing law is something which the arbitral tribunal will use to actually decide the rights and liability of the party. It is not to do with the procedure. Now, can two Indian parties have a governing law outside of India? Definitely not. The Indian Contract Act doesn't permit you. TDM infrastructure judgment doesn't permit you. We're very clear on that aspect. But if you're doing a cross-border dispute, then an Indian party and a French party can actually decide to have their laws governed by US law. Yeah, the beauty of arbitration, right? You could decide to have your governing law to be Hong Kong law, Chinese law. But yes, always have a caution. You should know what that law is, because you do not want to be subjected to something which you're not really aware of. You don't want to. So if anybody was to understand the concept of seat, I'm hoping in our subsequent webinars we'll cover them more, but very briefly, can I just say?
Kaushika is wanting to understand
yes,
that where to file the execution petition for enforcement of an arbitral award.
Perfect. So, okay.
Basically, how do you execute enforcement?
Absolutely.
And where would you go to enforce your award?
If you are two Indian parties, then of course you will be under the Part 1 of the Arbitration and Conciliation Act, and you could file your execution petition in any court within India where the party against whom you're seeking enforcement has any property or assets. Yes. Exactly. If you are, let's say, in an international commercial arbitration with a seat outside of India, so it's a foreign award. If your seat is outside, then your award becomes foreign. Remember that. And if it's a foreign award, then New York Convention comes into play. Madhvendra spoke about it. Yes. One of the best arbitration conventions.
All the jurisdictions which are signatory to the New York Convention, there you can go and you can actually, basically you have to decide that if your award is enforced in a particular place, would you be able to get your return? Will you be able to get your money out of that?
So let's say,
yes.
let's say that you have an award against an Indonesian party. You're an Indian party. And you know that that Indonesian party has some assets in China, some assets in Singapore, and also have some assets, let's say, in US, New York. You could actually file an enforcement proceeding in all the three countries and have your award realized. There's no difficulty. That's the beauty of New York Convention. But you should always remember that if your seat is India, and even if it is an international commercial arbitration, out of the 147 or 149 countries who have ratified the New York Convention, I think we have only notified about 47 or 50 countries. But most of your major world trading countries are notified in there. So it should not be difficulty. So when you're choosing your seat, you should also remember that that country is a New York Convention country.
Yes.
It's very important.
Yes.
Or at least if you're an Indian party, that is not only a New York Convention signed party, but is also a party where we have a reciprocity and the Indian government had gazetted it. I think we'll be very happy to share with the list of our speakers to what are these gazetted parties are after the webinar.
Yes, certainly. So Kushika, see, the point is, being from IIT, I like to keep things simple. The lawyers have a tendency to complicate and use all those complicated words. So if you want to enforce your award, basically your arbitration is concluded, you've got an award in your favor. You want to execute that award, basically to receive that money in question, right? So what you should do is, in any case, in the arbitration agreement, you would have referred, what your seat is. So that is clear. But wherever the award, first of all, you must see that jurisdiction is a part of the New York Convention. It's a signatory to the New York Convention. So they basically, that New York Convention applies there. And then you go to the local code of that jurisdiction. But always remember that when you're going for execution of your award, your contract and the arbitration agreement is once again subject to scrutiny of that law.
Yes.
So that is why if you are going into a contract with a party, see where you want to enforce your award tomorrow and see what is the governing law of that country. And insert that governing law in your arbitration agreement so that tomorrow you're going for an arbitration award enforcement. The courts again review your validity of the arbitration agreement based on their governing law, the validity of a contract, the capacity of the parties, and then the award itself.
And arbitrability as well.
So, subject matter.
So I can tell you this, that we've had examples very quickly where, let's say a dispute is with respect to a competition law issue, right? Now in US, the competition law issues are arbitrable. They're not arbitrable in India. So let's say, again, I go back to my example of Indian and French party, and they have some dispute which is revolving around competition law. And then antitrust law, as the US call it, and they wanted to enforce it. If they would have come to the Indian court to enforce it, the matter is non-arbitrable and the courts would have just thrown away the award itself.
Yes.
So you have to go to the US court to enforce it.
The subject matter has to be
exactly
arbitrable,
That's right.
Actually. So now see, but not much time we have. So Mr. Bal has asked a question that, is there any uniform code for counsels involved in arbitration?
Unfortunately not. The lawyers don't want to be subjected to anything. That's the whole thing. In fact, that brings me to another very interesting thing we always say, that people see and feel that arbitration is expensive. Ad hoc arbitration is expensive.
That's a myth, yes.
It's a myth because
of the counsels, I guess.
Exactly. So if you look at the study which has been done by ICC, it's available online, and I would request all of you to look into it. It is about cost in arbitration. And they say that if you're spending about 100 rupee in an arbitration, you spend about 2 rupee on the institution, 18 rupee on the arbitrator, and the rest is all on the counsel. And we do not regulate counsel fee. Everybody wants to regulate arbitrator's fee and the administrative fee. But there is no uniform code. Very recently, IBA, which is the International Bar Association, they had come up with something called as Code of Ethics for Counsel in Arbitration, but it's not enforceable. It's just a soft law.
There are various soft laws, basically kind of uniformity, to bring in uniformity in the procedure of arbitration is there. So, and basically the procedural laws will decide how arbitration needs to be conducted. But a uniform code for the counsels to conduct themselves is...
No.
So that is why they say, the legislators are litigators. So unless there's a distinction between the two, it's going to be difficult. So now Vikrant wants to know, what is the difference between the place and the seat of the arbitration and what effect. So once again, Vikrant, place is very immaterial in as far as the arbitration goes, whereas the seat is the heart of the arbitration agreement. Seat means that procedural law of that country, the law of that country will govern the arbitration, conduct of arbitration, the appointment of arbitrators, and how is the award has to be written. So all those ingredients are very important once you choose the seat. Whereas a place of arbitration is basically wherever you want to conduct that arbitration. You can say you can have a place. I mean, you want to go to Goa to conduct your arbitration, or you want to conduct your arbitration in Mumbai, you can just choose any place where basically both the parties should be agreeing and the amount of money you want to basically dish out or conduct an arbitration wherever you want to. It has to be a neutral venue. Generally, parties would consider that the venue, I mean, I would use venue and a place interchangeably because that is where the arbitration is being held. Parties would always want that venue to be neutral, away from the influence of both the parties, and where the tribunal would also have a very neutral environment to work in.
And where you probably might not have visa issues. But just if I
those
may
are
add,
other, yes, the peripheral, but they are important. Yes,
Yes,
you might
they're
just
very
touch upon
important.
them. Yes.
So let me answer you, Vikrant, on this. That India is one jurisdiction where we have used the word place in our Arbitration and Conciliation Act, and you don't see the word use seat.
Yes.
Internationally, seat is the word which is used. Even UNCITRAL model law actually uses place.
Yes.
But place, you have to understand, an international concept means venue. So there are three important concepts. I would say there is seat, there is place, and there is venue. In one arbitration itself, you can have more than 5 different venue or places. So today, the first hearing is held, let's say, in US. The next hearing is happening in Jaipur. The third hearing will happen in Hong Kong. The fourth one will happen in France. You can just keep changing your venue. The courts have nothing to do with it except for your visa issues, like I said, and the cost involved. You can keep changing your place/venue. But your seat is the notional concept where the court will have the jurisdiction. So when you challenge an award for setting it
Yes.
aside, you go to the seat court.
Court
That's what is the
assistance,
difference between
all the
the two.
assistance which you would need from a court. The
So if
seat
it's an
would be,
ad hoc
yes.
arbitration and you want to challenge an
Yeah,
arbitrator,
yes.
you go to the seat court. You
Yes.
want to go for an appointment of an arbitrator, you go to the seat court. I always say that for students, especially, to understand what is a seat, just remove the word seat and say arbitration act of that place. And that's about it.
So, Kushika now wants to know whether an arbitration clause providing for appointment of arbitrator by a single party is valid. So, Kushika, see, when you're signing a contract, it's a single document, right? Both the parties are signatory to that contract, and the arbitration agreement is one arbitration agreement. So, if the arbitration agreement has that, basically, let's say in case of government contracts, I can tell you because I have an experience with that, and I would like to also bring your attention to one of the case laws, which is Indian Oil versus Raja Transport. So now the government departments, whenever they're going into a contract, would always include, for example, the executive engineer of a department not directly indulge in that contract would be appointed as an arbitrator. And the other party who is accepting that contract is signed to it. That means, and remember, if the parties wish to enjoy the beauty of arbitration, but then you can't tomorrow stand up and have a disregard to one of the elements of it. So if both the parties have agreed that the appointment of an arbitrator would be done by the department which is giving out the contract, for example, Indian Oil Corporation, tomorrow you can't go and go with a petition to the court saying that I want the court to make an appointment. But this has happened in that case, in the case of IOC versus Raja Transport. The party, after the award was given, the party has gone to the High Court, and the High Court, the judge has ruled saying and by appointing a retired judge in this matter. And when this matter was again taken up, and they said that since the arbitration agreement both the parties have consented to has the method of appointment of an arbitrator and says the executive engineer has to be appointed by the department, that stands court. So that is why that court order was placed aside, and the appointment of an arbitrator was done by the Indian Oil Corporation as their executive engineer.
So I would say this in Indian law, in the context, I mean, internationally, of course, you can't have one party appointing it. It's against the party autonomy itself. in the Indian context, this has been a very vexed issue. We've had very controversial judgments coming out of both Supreme Courts and High Court. And I would say the law is still not settled. It's a little gray area because in different matters, depending upon the facts, the courts have interpreted it differently. But it seems to be more inclined that if it is a government body involved, like Madhvendra said, they have in more cases and not upheld the fact that you could have one party, which is the government party, appointing an arbitrator. But there is a rider, which is subject to the independence and impartiality of the arbitrator. So currently what's happening is that if you're in the railways, let's say a dispute against the railways is there, and if railways finance department is involved in the dispute, you probably could have an arbitrator who's an engineer, executive engineer in another branch of railways. So the two are not connected. Or somebody who's an ex-employee of the railways as well.
In fact, there's a case law on this also, MDRC, that is Delhi Metro versus one of the Swedish companies, I guess, where they have ruled that because contracting department, they said that cannot appoint their own people, but that ruling says that the department can appoint their own officers as far as the department, puts out the complete list of arbitrators, and they have an exhaustive list of arbitrators which encompasses all kinds of people, a long list of arbitrators, and that complete list of arbitrators is basically given out to the other party to choose from. You're not restricting his choice to one of the arbitrators or by name or by position like that. So another issue that in our discussion forum that one of the people had asked is, does the an award can still be enforced against an insolvent party, the party which has gone into insolvency? So I understand that this thing is recently in India also there is a new insolvency and bankruptcy board of India which has been created, right? So this matter has come into the light of late. So what happens is, in case the other party or the losing party has gone into insolvency, now I think that award will be enforceable or executable against the receivers of that insolvent, the other party who's going to receive the insolvent now. And as far as they have invoked Section 41 of the Arbitration of the Conciliation Act 96.
Can we go to just the next question? Somebody has asked us a question that if we can summarize. Oh, that's a good one. So we have to actually summarize our whole session, which says, can you summarize what are the essentials of a good arbitration clause? Do you want me to go?
Yeah, so go ahead.
So basically, I would say 4 points. One, of course, be very clear, like Madhvendra read out, pick up from any institution the first operative part of your arbitration award. That is, any dispute arising out of or in connection with this contract, including any questions regarding its validity, existence, termination, shall be settled by arbitration. Remember, shall be settled and not may be settled, because the moment you put may, it's again is not confirmed, and there have been cases where the arbitration agreement has been set aside. So shall be resolved either by ad hoc arbitration or by an institution. So you first pick that up. The second essential is going to be where your seat is going to be. Again, to be very careful, we'll repeat again, it's the arbitration act of that particular jurisdiction, which is a seat means, and that court will have the supervisory jurisdiction. Third, you pick up the language because you do not want to be saddled with an arbitration where you are unaware of it and you have to do your arbitration in a language unknown to you and increase your cost. Third, number of arbitrators. It always has to be an odd number. It is uneven number. So you can have 1, 3, 5, 7. Always advisable to go with either 1 or 3. Again, if the dispute is going to be a large amount, 3 is advisable. But if the amount claim is going to be less according to you, then keep it to 1, because then you don't add on to the cost of the arbitration. Fourth thing is going to be the law governing the arbitration. Yes. So that's your governing law. Like we said, two Indian parties have to have an Indian law. But in a cross-border dispute, you can have a governing law outside. I may want to be tempted to add just one last aspect to an arbitration clause, which is going to be your law of the arbitration agreement itself. Yes. So on what basis do you check the validity?
When you talk about the governing law, basically the law of the arbitration agreement, the law of the contract also, you can say.
Yes. So these are, I would say, the essentials
also,
of
and then you must remember that your arbitration agreement is not pathological. Yes. Remember of the validity of the arbitration agreement itself, and that would also come from the governing law. So you must, when you're putting a governing law, see that arbitration agreement, the capacity of the parties to get into arbitration agreement is fulfilled. And then you can also insert whether you want an ad hoc arbitration or an institutional arbitration. Institutional arbitration has its own advantages, and ad hoc arbitration has their own advantages. I have an institute sitting with me, but then, in my own opinion, I think that
Yes.
they both have their pros and cons. So, depending on what kind of contract you're getting into, please choose wisely.
Exactly.
And if once you're putting an institutional arbitration, do a study, a comparative study on which kind of institution you want to go in for. And then also, because I am from IIT and not a lawyer, but I have trained myself into an arbitration. I have dealt with a lot of matters in the Navy. I'm also a faculty now teaching at various places on the forum of various institutions. So if you ask me, I would suggest that when you're getting into an arbitration agreement, it is good, advisable to put the qualification of the arbitrator you would like to have. So depending on what kind of dispute arises. So not only the number of arbitrators, the constituent of the tribunal, you can also say that out of the 3 arbitrators that you want on the tribunal, what qualifications are you looking at? You're looking at one as an engineer, one as a lawyer, or one as a judge. I mean, those kind of things. I'm sure.
But
Also,
let me add a caution there.
yes,
Just be very careful not to specify qualifications too much. We've had places and clauses where parties have said that we want a trained arbitrator, fluent in English, with a technical background, recognized by a particular institution to be of so and so
that's not a
quality.
qualification.
So I would say that be very cautious. We've had
Yes.
some very weird cases
Yeah.
where parties basically had a person in mind, and
Okay.
rather than naming a person, they would
That's
just put
your,
all the qualifications
basically, you're
in
putting
there.
a specification of the people you
Yes,
want there, the
exactly.
person you want there. Somebody who has done his engineering from IIT Delhi, who was in the Navy, and
So I have something in front of me, if I may read out actually a
Okay.
pathological clause. It said that party shall appoint a Chinese-speaking arbitrator with a French law degree and a familiarity with Mid-East construction
you
contracts.
should have mentioned the name as well. What is
Sorry,
left?
yes.
Also, I mean, a complex arbitration agreement would need a lot of thought. Okay, to try and understand that, it's always good for the councils to look at all the aspects. But generally speaking, you could also mention when you're talking about the arbitration agreement, the qualification, the tribunal, the seat vacancy, the governing laws, the language, and if any other procedural aspect you would like to dwell upon, or both the parties agreeing you want a certain procedural aspect to be inserted, I think you can insert that as well. No?
Yes.
So,
Another word of advice or caution, if I may say, it is always advisable that you do have your arbitration clause vetted through an expert. Most of the institutions across the globe, actually, if you were to pick up a call and say that we would want to probably run by our arbitration clause, they will be happy to do it for you. I'm sure Madhvendra is there to, if you were to probably write to us and say that, can you just give me some
I'm
suggestions?
just giving out our email ID.
I'm happy to answer any questions on the drafting of arbitration clause as well. Of course, we're not giving any legal advice, I should say that, but just giving you suggestions at how you could make your arbitration clause more effective. So we're always happy to answer that.
Yes. Also, would you like to mention that basically coming out with something of the faculty that would, because as of today in India,
Yes.
there's no formal way of teaching arbitration. There are a lot of faculties, there are law colleges which are coming up with their own curriculums and all, but I mean that of international standards. Would you like to say like what kind?
Yeah, so what we've done is that we did realize that in a lot of law universities in India that arbitration is, or ADR is taught, but there is really no focus specifically on international commercial arbitration. So we have set up a faculty which consists of both Indian and international people, which consists of practitioners like myself, people, technical experts, I would say like Madhvendra, some retired judges, some sitting judges who have very graciously agreed to be a part of it. And we have developed and structured a program, which is about 20 hours program, which covers the whole nuances of your right from your drafting of arbitration clauses, the basic concepts of arbitration, how do you draft your notice, your statement of claim, witness statement to an award. So again, if any one of you would be interested about it, or any one of your universities or your organizations would be interested in it,
Yes.
we're always happy to
We'll
work
work
out
on
and see that how we can probably be doing this.
And remember, it's your eagerness to learn that brings us on board. So do keep in touch. I've given out my email ID as well. So get in touch, and we would soon be coming to your institute as well in some matter of time. And thank you for being online and giving us time on a Saturday. And we would be back again soon. And once again, Mr. Rohit Koshi, Mr. Bal, and Niti Sachdeva. Thank you all of you for this opportunity for us to come online and share our wisdom with all of you. So thank you, everyone. It was really nice talking to you.
Thank you to you as well,
so
Manvendra.
much. Okay.
Yes,